Hello, and welcome to today's episode on AI for Good. My name is Reinhard Scholl. I'm with the International Telecommunication Union, the ITU, and it is my pleasure to moderate today's session on Europe's proposed AI regulation. The ITU is the United Nations Specialized Agency for Information and Communication Technologies, and we are also the organizer of AI for Good, together with close to 40 UN sister organizations and co-convened by Switzerland. As usual, we count on your support to make this an exciting session, and please use the Q&A functionality if you have questions for the speaker. And for anything else, please use the chat tab. In April of this year, the European Commission published a proposal for AI regulation called the Artificial Intelligence Act, and the world is watching closely. Europe's GDPR, the General Data Protection Regulation, is being used as a model in many countries outside the European Union, and perhaps maybe the same might happen with the Artificial Intelligence Act. We are very pleased to welcome today Kilian Gross of the European Commission on AI for Good, and Kilian Gross is joining us from Brussels. Welcome to AI for Good.
Welcome, Reinhard. Thanks a lot.
So Mr. Gross is the head of the unit, which is responsible for drafting the AI Act. And to be sure, Mr. Gross and his colleagues did not draft this proposal behind closed doors, but there was a lengthy 3-year consultation process that preceded the publication, and anyone could submit input, and many stakeholders actually did so. Furthermore, you had a feedback period which closed on the 6th of August of this year, and you had received a bit more than 300 comments. So you have, and still, you had and you still have to square many circles for your proposed AI regulation, because different parties are pulling you in all kinds of directions. And one of the first circles that you had to square was how to define what you wanted to regulate. And you came up with an interesting solution. So could we put up the first slide, Gino, which shows the definition? So you have a general broad definition of actually not AI. You don't define AI, you define an AI system. And then you have an annex. The general definition, is pretty broad, and I guess, they all are pretty broad, and one definition is pretty much interchangeable with another definition. So let's look at the interesting part, which is the annex, where you list technologies. So it is often said that regulation should be technology neutral. So, and what should be regulated is the use of technology rather than the technology itself. So aren't you then with your Annex 3 regulating, or Annex 1 regulating technology rather than the use of it?
Thanks, Rainer, for the question. I think you're fully right. We should not regulate a technology, but we should regulate a use of a technology. Because a technology is neither good or evil. A technology is basically neutral. It depends what you do with the technology, and you can do a lot of good with AI, and you can do some harm with AI. And that's why we're discussing this today. So what we are actually regulating is, if you look at our, for instance, high-risk cases, or if you look at the provisions, and I'm sure we will speak about all this a bit later, are certain uses of AI. If you use AI in a certain context in law enforcement, or if you use AI for public social scoring, or if you use AI for recruitment, that is really the core of our regulation. That is exactly the use. But if we regulate, we have, of course, to be clear, what do we regulate? Because what technology is used? This is an intrinsic part of the whole regulation, because it's triggered then afterwards the regulatory intervention. And therefore, we needed the definition in Article 3, and in combination with Annex 1, which lists the 3 techniques, the 3 families of techniques, which you have here brought up on the screen, because this is needed in order to show which kind of use of a technology is indeed regulated under this act. And therefore, we needed this, this definition and this list of techniques to provide clarity. If you want to use a advanced, sophisticated software for a given purpose, when will you fall under the AI Act?
Mm-hmm. So now, not every technology listed in point C, like statistical approaches, might necessarily have to do something with AI. Isn't that rather broad, perhaps, your point C of Annex 1?
Well, this is a criticism which is indeed sometimes made, that Bayesian systems or statistical approaches are too far-reaching, and that we may cover things which do not really display the particular risks which we want to regulate with regard to AI, and that is indeed the justification for the whole regulation. But I think you need to see two things. The first is that the Annex 1 is not a self-standing definition. The definition is indeed in Article 3. And the definition in Article 3 is largely based on the definition from the OECD, which is, in our view, the most internationally recognized definition of artificial intelligence from all member states of the OECD. And here we say an artificial intelligence system means software that is developed with one or more of the techniques and approaches listed in Annex 1 and can, for a given set of human-defined objectives, generate output such as content, predictions, recommendations, or decisions influencing the environments they interact with. And this shows already, if you read this, that Annex 1 is one element of the definition, but it's not the definition as such. There are cases when you use statistical approaches, which are not AI, because you do not fulfill the other criteria of the definition. Okay. And this is in particular true because you need, in the definition, you see we have generate output. So you have an input and you have to generate output, and we understand that this must be a process where you, from a given input data, you reach a certain output. This is not always the case if you just have a linear connection between two dots, and therefore it's a necessary but not a sufficient condition that you use one of the conditions of the techniques listed in Annex 1.
Okay, thank you, Ian. Before we move to the one of the next articles, we'd like to do a poll. So we'd like to see how familiar you are with the proposed AI Act. So here is the poll. If you take a few seconds to choose one of those four options. So how familiar are you with the proposed European AI Act? So one option is I've studied the proposal in detail. The next option is that you have maybe just glanced at the proposal. The third option is I have not looked at the proposal, but I have heard about it. And the last option would be that you have not heard about the proposal at all. So let's give it a few more seconds, and then perhaps, Bastian, if we can display the results. So I have studied the proposal, okay, 80%. I have glanced, 30. I have not looked, 35, and I have not heard about it, almost 20. Okay, thanks very much. Okay, now let's go, Gino, to the next slide, please. Okay, so the European Commission, you adopted a risk-based approach. So risk-based means the higher the potential dangers for a specific AI system, the higher the regulatory requirements. So this diagram is not included in the regulation, but you and your colleagues are using it often when you're presenting the regulation. And so you have defined four risk categories, which you present in a four-level pyramid. So you distinguish between unacceptable risk, high risk, limited risk, and minimal risk. So let's start at the bottom of the pyramid. And AI systems with minimal or no risk will not be regulated. And I guess the assumption is that most of the products and services, maybe 80 or something like that percent, will fall into that category. So the risk category for the same product may change depending on who is buying the product. For example, if you have a startup that's selling a face recognition tool to a company that wants to use it to check the identity of the people that are entering its building, I guess that would be a minimal or no risk case. But if the same software were to be sold to a police department, that would change the risk category. Is that correct? And if so, what does the startup have to do with that selling the product?
Well, in principle, it's correct. Perhaps the example is not ideal because we would not consider this as facial recognition, but authentication, because here it's about authentifying who is entering a building, because it's a closed environment. You're voluntarily exposing yourself to this check. and you are in a, you know that you're in that database which you are controlled against. So we would therefore be, normally we would not consider this as particularly risky because this is not for us biometric remote identification. But you are, you're right in what you say in principle, because indeed it may depend for which purpose an AI system is used. And for different purposes, this may lead to different risk assessments. So it can be that a similar AI system in one context is, for instance, rather innocent and would be considered as a minimal or low risk, whereas in other circumstances it may be much higher, of a much higher risk. So that is, for instance, if you and this is for, if you, for instance, use emotion recognition in a given context of a job interview, we will consider it as being high risk because this is a very delicate situation if you check the emotions of your applicant. If you use emotion recognition just as a shop to check whether your customers are pleased with a certain advertising, we would consider to be enough that you just inform your clients that you're scanning them or that you're analyzing them in that particular way. That would be Article 52. This is, in our view, logical because, as you said, as a starting point, we don't regulate a technology, we regulate the use. And the technology may be used for something which is very important for an individual, and we have a whole matrix of risks in Article 7, paragraph 2, because the individual is in an important situation. In the recruitment context, it is important for you to get a job or to present yourself in a fair and non-discriminatory way. In a shopping situation, it is a completely different social context. Now, of course, you ask the logical question, how can the provider know this if he or she prepares a product for being placed on the market or put into service? Yeah, our answer is very straightforward. He does not need to know. He has to define, and this is a commercial choice, for which purposes or which uses the product, the AI system, which we treat as a product, shall be used. And for this, he will assess whether he needs a conformity assessment or certification or not. And this is a normal choice of a product designer, because if you go to the classical product world, you have to decide what is the intended purpose of your product, and this will designate basically, is it for kids? Is it a product that we use for kids? Is it a machine interacting with humans? This will, of course, have an effect and an impact on your risk classification, and that's the same here. So in the end, for the AI provider, it's a commercial choice to decide whether he or she wants to cover all potential users, which may include high-risk users, or whether he wants deliberately only to say, to prescribe that this AI system should be used for systems which are not classified as high-risk intended users.
Okay, good, thank you. Let's move to the next level in the pyramid. So these are, yeah, that's fine. Yeah, Gina, you can go to the next one, transparency risk. If you go to the next one, next slide. Yeah, Gina, thank you. So you have for AI systems which would fall into that category, special transparency obligations, disclosure obligations must be met, and there are 3 categories. So let's look at the first one, which is interacting with bots. So, and it says that humans have to be notified when they're interacting with a bot. How would that work in practice? So, suppose I go to a restaurant and the chatbot takes my reservation. Would the chatbot introduce itself and say, "Hi, I'm a chatbot. Can I take your reservation?"
Yeah, that could indeed be one way of doing it. And here I have to say, because you mentioned, and we are grateful for this, that this has not been developed in isolation by just reflecting in a small group, but with a lot of social interaction. And we had a public consultation with more than 1,200 submissions and more than 400 PDFs. There's a lot of public interaction. Our AI Alliance events may be mentioned as some of them. And one key request from the public was that the individual needs to be informed when they're interacting with a machine. This is felt like an important element of human dignity, that you don't speak to an automated device and you're not aware that you're speaking or interacting. It may as well be in writing. You may as well send your email, or you may have a chat and you may exchange with this chat in this function that doesn't change. But that is felt largely as a limitation or restriction on human dignity. So if in case you don't get a table and you get excited and you start to shout at this chatbot because you think that you have reserved and there was a mistake and you were always the best client of this restaurant, and afterwards it turns out that you have wasted all your time and energy because you have spoken to a machine, that should not happen. And indeed, we leave it open to the provider to decide how this should be clarified. There are different ways of doing it, but for us, it's an obligation of the result. You need to make sure that the user in the end is aware he's not speaking to machine. It doesn't make any sense to use your charm or to exercise any kind of pressure because you're just working with a machine which will follow an algorithm and follow certain decision structure.
What about text that's written by text generation systems like GPT-3? Would an article that a newspaper writes using GPT-3, would that have to be mentioned that it's written by AI?
I mean, it's all, as a lawyer, I can of course always answer this depends, but in principle, I wouldn't say so because a text is not really an interaction. Because what we here target in Article 52 is this one-to-one interaction. You are interacting with a machine, and from the context, you cannot distinguish immediately that you're not interacting with a human. So you may legitimately believe that you're interacting with a human being, you're writing to a human being or to a machine, you get a written answer, you're talking, you get an answer. This is the situation we're looking at. If you read a text, it's a different story because that is a fixed piece of information which has been set up. It would not fall under our category of deep fake because here we speak really about images, audio, and video content. So we would normally not be in that category. So I would not see, at least in the general context, this obligation triggered. It could be different if this text is generated in a circumstances of a chatbot, but that I think is a bit of a very special case.
Okay, let's move to the next category. If we go to the next slide. That refers to transparency obligations for emotion recognition system and biometric categorization. Can you give your favorite use case for each one of them?
Well, as I said, and you could show this or you could see that on our famous pyramid, we don't exclude different levels of risk. So we say emotion recognition is in any case triggers a specific transparency obligation. That's number one. Here we think about, let's say, less tricky situations. You go into a shop or you go on an online page and the camera is used to see your satisfaction. And this could help then to optimize the offer. Or that could help the shop owner to see whether a certain product or certain advertising is well received because you are smiling, you're happy, you find it funny what you see, or you are disturbed. This is, in our view, less critical, but you should be informed. And this information should then normally put you into a position to say, no, I don't want to be emotionally analyzed. I don't want this. I can leave the page, or I would presume that most providers, because they want to keep you on the page, will offer you then the option, okay, switch off your camera, or you can choose not to be analyzed. So then we will not be able to optimize as well as we could otherwise do our personalized offer to you. This is then your choice. This is what we target here. At the same time, we are aware that emotion recognition can be very sensitive. If emotion recognition is used, let's take it in an exam for a student, whether you're cheating, or emotion recognition is used in a recruitment context, which I just mentioned, to check whether the applicant is feeling at ease in a certain situation. Here, this is a completely different scenario, because here we would be in a high-risk case, not because of the emotion recognition, but because recruitment is a high-risk scenario, and therefore we would consider then the system applied in the recruitment context, again, for the intended purpose of recruitment, as a high-risk system. And the transparency obligation would come on top. The applicant or the student, in my example, would have to be informed about the emotion recognition, but it would then as well be a high-risk case. This is just to reply, because often people say, but emotion recognition is very risky and it's scientifically not sound, and therefore there is a risk of failure. This is true. And therefore, if it's used in socially sensitive contexts, we consider it to be high risk, and we will only allow it when it passes our test of being trustworthy.
Okay, thank you very much. Let's move to the next category within the transparency obligation, and that relates to deep fakes. So deepfakes, I think, and I guess many people are a major risk for humankind. When you can easily come up with horror scenarios that could lead to social uprising or maybe even wars. So shouldn't deep fakes be put in a high risk or maybe even in a prohibited category? For example, you could imagine that one might prohibit non-consensual deep fake pornography.
Well, we have in the high risk categories, we have 8 categories, and we have the possibility to extend these categories for use cases if we think there is evidence that we need to add something. And there, for instance, in the category 8, we have democratic processes. So there would be an option in the future if we identify another use case to add elements. I think this is important for our methodology because we really tried only to bring up cases where we have evidence and that we can say we know that already there is a problem and we do not expect there may be a problem at some point. With regard to deepfakes, we know that this is a very considerable problem, and this is probably not a problem which we will solve alone with this act, and we don't pretend this, because here we look at AI and we look at the specific danger AI is generating, because AI may make these deepfakes much more powerful and much more convincing because it can perfectionize this technique. And we think the most appropriate tool there is the labeling, because as long as it is labeled that something is not naturally generated, is not a copy of reality, but it's something else, because it falsely appeared to be authentic or truthful, or it is it is manipulated in the way that it appreciably resembles existing persons. As long as you so the persons exist but not in this context, or you give an impression that something is real which is not real, if it's indicated that this is a deep fake, then normally a good part of the problem should normally be solved. Because this is indeed, if for instance the AI system would automatically generating this kind of pictures, would automatically generate a disclaimer, this is a deep fake, or this is an artificially generated picture, that would already help a lot. And you will of course not solve all the issues, because you may say, but how to control it, and people may misuse it, and it's not this will not solve everything. But first, it could solve, I think, a lot, because it will be a strong, it will prescribe basically for providers to make this normally automatically happen, that there is an indication. And second, if you use such a deep fake, you will automatically use something illegal, which will have consequences in the different legal orders. So it will have an important effect, and we think it can contribute significantly to this important debate on how to have a fair and real discussion in our democratic societies.
The way the labeling is done, is that something that the standards organizations would make a proposal for, or how would that be decided?
We have not yet really decided on this. We wouldn't exclude that. I think the standards will mainly come in on the requirements and on the different use cases, on the high risk. That's where we see particularly the need for technical standards. Here on Article 52 and Article 5 on the prohibitions, we would mainly see perhaps the need for further guidance. And this will certainly be provided. So once, because as you all know, this is a proposal, and this is what the Commission suggests to the co-legislators. Now we are, as it should be, in the hands of our member states and of our parliament, so they will decide what will be, in the end, will become good law. If our co-legislators were to decide that this should become good law, then of course we will provide further guidance and explain further in detail examples, ways how to do it, what we would consider to be satisfactory or unsatisfactory.
The obligation is on the user of an AI system, and on the previous slide we had a definition of the user. So what's exempt in your user definition are, it says, where the AI system is used in the course of a personal, non-professional activity. So if a teenager is putting up a deep fake on TikTok, that wouldn't have to be labeled, or would it have to be labeled?
Yes, if it's a personal, non-professional activity, he would not be a user, and therefore it would not fall under that obligation, for the simple reason that we didn't want to criminalize or to overburden the average user who is not a professional. The professional user we expect, and the user is for us the person controlling the system. The professional user, we expect that he or she should be aware of the legal obligations and commitments. But we were of the opinion, but it's of course something you may discuss, but we were of the opinion that in particular in these cases, you cannot expect from every user in the internet that he or she is fully aware of all these legal restrictions and constraints. And we still want to have an open use of the internet. So we would like then to increase the level of obligation vis-a-vis professional users.
So suppose a professional company is putting up a deep fake on YouTube, and let's say the professional company is in Australia. So neither Australia nor the United States are part of the European Union. So, but the like millions of people could watch it. So would the deep fake have to be labeled by the Australian company?
If the deepfake can be seen in Europe, and I understand this is the case, this is open as well for European viewers, then it would have to be labeled. Otherwise, in Europe, it would violate the obligation. Here we try in Article 2, we try to really create a level playing field, and we want to avoid circumvention. So even if the user and the provider, I should start the other way around, the provider and the user are situated in a third country, but the result is displayed in the union, we apply, as far as the union is concerned, our legislation, because otherwise this regulation would easily turn into an incentive to move to third countries and then to do everything and to basically serve our market from a third country. And this is exactly what we don't want. We want to have a level playing field and a fair use of these tools on our market. And as long as this is visible and reachable on our market, you have to comply with our rules.
Why do you have exceptions for labeling deep fakes? You have a freedom of expression or freedom of the arts and sciences. Are you losing anything if those were labeled as deep fakes?
Well, here we have different fundamental rights which come into play, because we have a freedom of expression and we have a freedom of science, and we have as well this exception here for criminal prosecution. This is mainly meant, for instance, for child pornography, when police authorities need to create a deep fake in order to have access to circles of criminals in order to do their investigation. So we think that these are needed in order to comply with our legal order, because if an artist needs to create a deep fake because that is his way of expressing his inner feelings or his vision of the world, and he feels, or she, I should not use always he, feels that this is would be disturbed by labeling it, that is fine with us, because and in general we would understand that this would normally be visible as a piece of art, so that should normally not create a big problem. So we don't want to intervene into this. So this is a very delicate balance for us, because we want to protect a right of a fair discussion and a democratic process, but at the same time, of course, it's part of this right that people can say whatever they want, more or less, within certain minimal limits.
Okay, good. Thank you very much. Let's move to the next slide, and we move to the. So we have spoken about the minimal no risk. We have just seen the transparency obligations in the transparency risk category. Now let's move to high risk scenarios. Next slide, please, Gino. So they come basically in two categories. So the first category covers AI systems which are embedded in products that are already subject to a third-party assessment under legislation which is specific to certain industry sectors, so like machinery or medical devices or toys. So that's already covered by some regulation. So let's move to the second category. Next slide, please. This second category focuses on AI systems that are not embedded in other products. And the regulation, you consider these standalone systems here as high risk, and you have an annex which has 8 categories with quite a good number of use cases, which I captured a bit in yellow here. Could you pick maybe one or two use cases so that we can get a feeling for what would be high risk?
Yes, I can do so with pleasure, but of course, we all consider them to be important. The first perhaps is astonishing for you is biometric identification, because we have as well a ban in Article 5. I think we'll come to that later. But this is, to be clear, in certain cases, we still allow biometric identification, but we consider it to be high risk because here the accuracy, for instance, is very important. If you have a false positive of 1% and you screen 100,000 people a day, you still have 1,000 people which are falsely identified. Therefore, this is just an example. Or there is a risk that you discriminate because the system may work better on certain ethnicities than on others. It may work better because there have been more men in the database than females, so it may work better on men than on females. So this is certainly something which we would consider to be high risk. Or another one is, I think, very interesting is the whole world of employment. You have in employment, you have, as we all know, AI is very data dependent, and the data in employment is often based on the past. And the past was unfortunately not perfect because there may be companies with lots of male white men and with a certain educational background. And if you just use this data without really controlling this, the AI system will always present or propose similar candidates for job interviews or for posts. So there we see, for instance, this is a very important point for society that if we want to have a fair society which is aware and vigilant of discrimination, we need to make sure that these data sets do not lead to perpetuation of discriminatory patterns from the past into the future. And therefore they need to be checked and controlled. It doesn't mean they should not be done because it can be very useful. It can even help to overcome prejudices because even without AI, you may use discriminatory presumptions in your assessment, but you need to be aware of this and to check this.
Okay. Manufacturer of an AI system in the high-risk category must perform conformity assessment. If we go to the next slide, so conformity assessment means basically, that's the process of verifying that the requirements that are set out in the regulation have been fulfilled. And there is, the idea is actually that the manufacturer itself is going to do the conformity assessment, and the idea is the manufacturer knows best about it. So it's not a third party, an outside party that's doing the conformity assessment, but the manufacturer. So, and there is quite a long requirements that need to be fulfilled for the conformity assessment. Could you summarize the requirements that are needed on part of the manufacturer?
Well, the requirements which are checked on substance in this ex-ante conformity assessment are those which already the high-level expert group has identified in the past and which we have tested in our pilot project and which are underlying this famous Altai tool for self-assessment. And these are, and we have listed them up already in the white paper. So I think they should normally not come as a surprise to this process. And there are, I would call them merely the classical requirements now. We look mainly at data, whether the data are sufficiently representative, whether they are solid, whether they are free of error, complete, and so on. We secondly look at the documentation, because this is really important for afterwards checking whether how the decision has been taken, and if something went wrong, to check why. The record keeping, in the same vein, the transparency in the information requirements for the user, so the user must understand the system and must use it correctly, therefore he needs to be correctly informed. Very important, the human oversight, which can either be built in the system or can be part of the instructions of the provider. And then last but not least, the accuracy, robustness, and cybersecurity. So the system must work well. These are the 5 set of requirements which are checked in this ex-ante conformity assessment. And they are, as you show the slide, they will be translated into harmonized standards. This is what we call in the EU jargon, this new legislative approach, the new legislative framework. We don't put technical specifications into the legal act because they will move. We will have a moving state of the art, but we give abstract criteria, benchmarks, what we want to achieve, and then we will fill that out with standards, which will then come in order to give the details.
So standards are going to be very important, and standards organizations are going to be very important actors. And you could say this is where the rubber hits the road. So does the European Commission have a plan which standards are needed?
Well, it's clear that we need an active standardization policy in this respect, because it's a crucial element of this regulation is that at the end, And we have a 2-year transitional period after the adoption of the regulation, that once this period is over, that the standards are there. So we are closely following that. We had already a JRC study on standards in AI. We work with the European standardization organizations. CEN and CENELEC have already created a joint technical committee to analyze this. So the work, I think, has started. We will have only a completely final mapping, of course, once we have an adopted act, because this will depend on which cases will end up on the list of use cases, and this will be subject to political scrutiny and political decision. But it is clear that we cannot just wait, but we will have an active standardization policy in order to make sure that once this transitional period is over, the necessary standards are available.
How would you decide whether the standard is satisfactory or whether it's insufficient?
This is a classical way. I mean, you know, there is a standardization regulation in the EU where we look always at standards, because under this whole product legislation, it needs to be checked whether a standard allows the presumption of conformity with a given technical requirement. That is a standard process we do. So we mandate European standardization organizations to develop a standard. They develop a standard, and in the end, the standard is assessed by the Commission whether we consider that the standard meets the requirement. Because the consequence of a harmonized standard, if it's published in the official journal, is that a provider may use that standard, and there's a presumption of conformity with the requirement if the standard is complied with. So it's a very important element. And in this assessment of sufficiency, we check whether this presumption is justified, whether if you have fulfilled this standard, we are convinced that the requirements which the standard should respond to are complied with.
I mean, standardization sometimes takes a bit of time. What would you do if the standards are not completed on time?
Well, we of course know that there is some time pressure, so we will issue a mandate, and we will ask in that mandate, of course, as well for a timeline, and then the standardization organizations have the chance either to accept this timeline or to ask for a different timeline. And once we have agreed on a timeline, this timeline becomes binding for us. So it's not just a process where we wait and see, but it's a process which is organized, where we ask to be ready at a given point in time, and the standardization organizations have to reply whether they can do this, and then they commit to comply with the timeline. We have then, in addition, we have what you have here in Article 41. We have the possibility of preparing common specifications that can be a means to fill a gap. If there is no standard or the standards are insufficient, the Commission can, via implementing acts, adopt these common specifications, and they can basically then take the role of the standard, namely translate the requirement into something very concrete, what the provider has to do. And last but not least, you should not forget, and as well, this is common in product legislation, standards are not compulsory. So the provider can always show the compliance with the requirement even without a standard. It can be more burdensome, but it's not excluded.
Okay, yeah, good point. Okay, let's move to the next category, the highest category. So we have dealt with minimal risk, transparency risk, high risk, and now we go to the unacceptable risk. Next slide. So you have 4 prohibited categories, and I think 2 could be bunched together under the term of manipulation. Then you have 1 on social scoring and 1 on biometric identification systems, real time. So let's look at manipulation here. So, certain acts here are prohibited, and namely those which exploit vulnerabilities either through subliminal techniques, or maybe if the person is due to age or physical or mental disability not adapted to recognizing that. So in the presentations that you give, you have a use case which sounds a little bit maybe coming almost out of a science fiction novel, where you say maybe like an inaudible sound in a truck driver's cabin, which might push the truck driver longer than healthy and safe. And the AI would be used to find this frequency to maximize this effect on a driver. You have perhaps maybe another use case that would fall under manipulation?
Well, perhaps first it's important to describe a bit the background. We only want to prohibitions are, of course, the toughest intervention we can propose, so we were careful with this. And we looked at this as well in the context of other EU acts. So it should not be misunderstood. Not everything which is not listed is laudable or is ideal. We have just listed things where we think there is a specific risk on AI caused by AI, which is not yet addressed by other acts, like the Digital Service Act, which is in negotiations, or the Unfair Commercial Practices Directive, or other consumer protection directives or non-discrimination legislation. So you need to see this in context. Otherwise, you may say, but why are you only prohibiting so little? We prohibit where we see there's a gap and there's a particular risk due to AI. And that's why we here link ourselves as well to subliminal technique, because we think that the normal, let's say, abusive advertising, influencing, which may be harmful, unpleasant, undesirable, is sufficiently addressed in the Digital Services Act and in the Unfair Commercial Practices Directive. So what we look here at is, if you go beyond that, if you use AI to address the subconsciousness and the person is not even aware and can therefore not really take a free or informed decision, and this leads to physical or psychological harm, this is really something which we find completely unacceptable. And this is empowered by AI because you can better understand how the individual psychologically works. And here, there are perhaps not an enormous amount of applications, but there are important cases. And we think, for instance, if you don't like our example, which we have taken so far in the public presentations, you could as well think about an experience in extended reality applications where the person is receives a very intensified and persuasive experience, and it could be misused, this intensity, the sensory experience to incite someone to do something harmful they would normally not be doing. Or another thing would be that you have a personal assistant which is optimized to increase your economic benefits for certain companies that gives advice for unhealthy diet or unhealthy daily regime to consumers. So you have your personal assistant and he tells you all the time, now it would be nice to have a nice package of crisps that would do you good. And it's not about this personalizing, but it's really about that the AI is understanding your psychologically and abusing your psychological weakness in addressing you in a way which is subliminal. And subliminal is not a new term, it's a term which is defined in the Audiovisual Media Directive.
But isn't it hard to prove whether something is causing psychological harm? Also, you may have harm that only occurs when you add up a number of single events.
Well, of course, this may not be obvious to show, but if somebody, for instance, plays much more or stays much more time in this virtual reality, then it does do him good or her good, then I think you can show this harm. And we want really to qualify this because we prohibit this. This doesn't mean a prohibition means it is not allowed. It will be sanctioned with the highest possible sanction we have. It will be prohibited under all national legal orders because it will violate a legal rule, which is here set up in Article 5, paragraph 1. So there is no moderation, there is no proportionality test. And therefore, we need to be very clear that there must be some harm or likelihood to create harm, because otherwise we would create an uncertainty what is allowed and what is not allowed.
So if manipulation does not cause individual harm, that's fine. So you could imagine in a manipulative AI system, that does not do individual harm, but societal harm, like spreading misinformation.
I don't say that it would be fine. That was my introductory remark. Not everything which is not prohibited is laudable or desirable. But we think, for instance, this kind of recommender systems will be appropriately dealt with by the DSA. And there we have basically a moduled level of intervention, how to deal with these kind of situations. And so we have instruments there in place to do this. What we here want to cut off are really the extremes. That doesn't mean that any kind of other ways of personal advertising, which may cause financial harm to you because you are so much pushed and it's so difficult to end a contract that you never end an abonnement, or there is an unfair psychological pressure on you because there's a watch and it's ticking and you need to do something in 5 seconds, otherwise the offer may disappear. Or this may be cheating, or this may be disturbing for the consumer. It may create some financial harm on you, but there are already some instruments to deal with this. And we wanted here to really to take the peak of the iceberg.
Okay. Let's go to the third case of prohibited AI practices. Let's go to the next slide, and that refers to social scoring. Gino, if you go to the next slide. Yeah, okay. So the regulation doesn't have a definition of social score, and you don't have a definition of trustworthiness. And in the literature, there are different terms used, like financial credit scores, and then there are thousands probably of consumer scores. Then there is a social score that you have here in the regulation. Are these, how do these terms relate to each other? So which scores would be allowed?
I mean, I think we define the term what we mean in Article 5. I mean, you don't find it's correct in the list of definitions, but that's due to a simple legal technique. If something only appears once in a legal text, we don't define it in the list of definitions, we define it where it occurs. So what is important for us is that hopefully if we manage to do our job well, then Article 5 should clarify this sufficiently what is meant. And here we say in Article 5, and you put this on the screen, it's the placing on the market, putting into service of an AI system for the evaluation or classification of trustworthiness of a natural person over a certain period of time based on behavior or known or predicted personality characteristics, social score, leading to either or both of the following. And then you have this detrimental or unfavorable treatment or detriment of natural persons, groups thereof in social contexts. And this is important, which are unrelated to the context in which the data was generated. So you take data from a different social context and you use it to evaluate a person or a group of persons in a completely different social context. So for instance, you take data from social media and you just use it to score them, for instance, should they be eligible to social subsidies, to social support. Or second, the way you do this is unjustified and disproportionate to the gravity and the of the behavior. So you basically overdo the data analysis. So these are the two scenarios. You use data from a different context or you use them in a disproportionate manner. And that leads then to this classification or evaluation, which has a social consequence.
Mm-hmm. I mean, I understand that the public authorities are not allowed to compile such a social score, but and they cannot also ask private companies to give it to them. But a private company could actually compile a social score and maybe publish it.
Under our list of prohibitions, a private company so far would not be prohibited of doing so. Again, this because we understand that this, of course, this kind of classification or ranking of customers is done quite a lot in the private context in different ways, with different intensities. So I think it's a larger debate where you need probably again a more proportionate answer. And we are here. This may as well happen in recommender systems because you look at how your client is structured, what you want to offer to your client, what category of client how you want to treat a certain person. I think therefore we need more moderated responses. Here we think for the public, again, we don't think that everything else which may happen, social scoring by private is perfect, but we think that we need a differentiated answer, and that could be given, for instance, in the DSA. Whereas we think for public authorities, this kind of social scoring, that I look at the social media to identify whether somebody has the right, and these are real cases, has a right to get an allowance for social housing, and I screen the social media account of these persons, that is unacceptable. And therefore we don't need to have other instruments or a moderated response, we just say no.
Okay. In the text, it also says with the social score leading to one of the two outcomes cited. So, I mean, a vendor could simply deny a negative outcome and blame it on the natural person.
Well, again, in the vendor context, you would be probably in a private context, so that would not really fit into this prohibition. Okay. You would then be, I think, in the context of the DSA, the Digital Services Act. I understand.
Mm-hmm. And in general, I mean, if a vendor sells a general purpose AI system, which the user could then use and configure and maybe disguise the true market of the AI system, are there any safeguards against that?
Well, this is, I think, the question you asked in the beginning about the purpose and the intended use. Mm-hmm. If there's a general purpose AI system, which is just permitted for low or minimal risk categories, and the user decides, okay, I want to do something high risk or even something prohibited, then the user becomes a provider. In particular, if it's prohibited, it's prohibited. He doesn't need to do anything else because he just should stop doing it. But if he wants to do something which is high risk, then he would become himself a provider or herself, and he would need to undergo the assessment.
Okay, let's go to the last case, the fourth case, which is prohibited. So these are real-time remote biometric identification systems in public accessible spaces with some exceptions. So real-time means, okay, you have it in your regulation instantaneously or near instantaneously or without a significant delay. So the data could be analyzed biometrically like the day after or maybe 2 hours later. Would that then fall into the high risk category, or would that not be allowed?
We distinguish between real time and post use of this biometric data, and there is a simple reason for this, because if you are in the post scenario, you normally have time, and you normally would double check. So if there's a police authority checking the video footage, let's say there were riots after the G20 in Hamburg, and then in the months afterwards, the police would use video footage in order to identify offenders. And they would use biometric tools to identify whether certain persons which they've identified have been active in certain violations. Then they have a lot of time, and they can double check, they can cross check, they can validate the information they received from this video footage and or from the biometric system put on that video footage. And therefore it's a different level of risk. If you're in the real-time scenario, then we speak about the scenario, there is a video camera, a video footage. The camera takes pictures of people in the public space who often are not fully aware, or maybe aware, but they don't really realize this, or could be aware. And they have a list of, a search list. And in the moment the system identifies somebody on the search list, for instance, it's somebody exposed to, who's supposed to be a terroristic threat, then probably the police authorities would intervene immediately. And that would expose that person to a much higher risk. Because as I said in the beginning, we always treat, even in the case where it's permitted, we treat biometric identification as a high risk, because there is a good chance that the system, or there is a chance that the system may not function perfectly well, and that we need to avoid. But in the case of the real time, this may have very serious consequences, because the intervention will happen on the spot and may expose that person to significant personal danger. Whereas in the ex post scenario, even if something goes wrong, he can contest, and then there will be a verification, and this can be controlled. That may be unpleasant, yes, and it should only be done to the highest possible standard. Therefore, it's a high risk scenario, but the intrusion and the exposure is less than in a real-time scenario.
Could you give a number? How many minutes would be between real-time and post?
I mean, we try to give it a definition in Article 3.37, and there we say real-time remote biometric identification means a remote biometric system whereby by the capturing of biometric data and the comparison and the identification all occur without significant delay. This comprises not only instant identification, but it's also limited to short delays in order to avoid circumvention. We have deliberately not put in there 2 minutes, 5 minutes, because that would lead then to circumvention, because you would just have to delay your system 5 minutes and then you can do whatever you want. What is important for us is really, is this something used on the spot? So would that lead to intervention whenever the identification takes place, because you know, there the guy is, or the lady is running on the train station, and this is the lady or the guy I'm looking for as police. Now I will start my machine and then I will try to capture them. That is, in our view, real. If the system is slower or quicker, it doesn't really make a difference. Or if the police officer perhaps had a coffee and is just looking 1 minute later on the system, but still takes this immediate action, this is the difference. On the other hand, the post scenario is a scenario where the event is over. The person is no longer there where you see it on the video footage, but you use it, for instance, to investigate a past event.
Okay. The provision talks about the use of real-time, etc., and the other provisions talked about the placing on the market. So could a vendor in the EU sell an AI system that would be illegal to be used within the European Union, but could be used by a country outside the European Union?
Well, I mean, we, as I said, we ban or prohibit the use of remote biometric identification system in publicly accessible spaces in real time. Mm-hmm. So there are legal use cases in the Union. You can be another body, you can be a private body, or you can do it ex post. So it's not, we cannot say that the technology as such would be, I know that this is a politically very disputed article and there are a lot of different opinions about this, but in case the co-legislators would adopt this like as it stands, there would still be cases where you could legally use this biometric identification tool, and therefore it's not prohibited as such. What is prohibited are certain uses. And by the way, this is very important, and I always try to stress this. You should be aware that, of course, all this is subject to the full application of our data protection acquis. This is always, well, not always, this is sometimes overlooked. I have to be careful. I get driven away by all these questions because we have a general data protection regulation, which in Article 9 prohibits the processing of biometric data with a few exceptions. And there's the same in Article 10 of the Law Enforcement Directive. So you can only do it if, of course, and that's a precondition, if the data processing is legal. That's the first condition. And you have to pass there normally the data protection authority. So it's not, because if the data, if you're not allowed to use the data, then of course you cannot use a biometric system. If the data are collected legally, then on top of this, you have our conditions.
Okay, good. Last question, and then we will finish on the hour. What's the timeline for this becoming to be a law and being applicable?
Well, we hope, because we think it's important, that it will become law soon, but of course we need to be a bit realistic. We are intensively working in the council, and we will hopefully have a compromise text, the first compromise text towards the end of this year. The parliament is in the next 2-3 weeks, deciding on the final configuration in which they want to work on this. And then I hope we can very soon work with both institutions at full speed in order to come to an agreement at one point next year.
Okay, thanks very much. So this was Kilian Gross from the European Commission. Thank you very much for your time. You're very much in demand, and thank you very much for having found the time to be with us. Thank you. Bye-bye.
Thanks to you for all the questions, and thanks to the audience for your patience and your interest. Thanks a lot, and have a good afternoon. Thank you.
Thank you. So
bye-bye.
Bye-bye. So that concludes our AI for Good for today. And to our audience, we have almost daily programming. So please stay tuned and check out our program on AI for Good. Thank you very much. Bye-bye. Actually, as a last thing, if you let us know whether you like this webinar. And here is the Net Promoter Score. If you please take 5 seconds and evaluate how you liked it. Thank you very much.
Selector, rewind selector, rewind selector, rewind selector, rewind selector, rewind selector. Selector, rewind selector, rewind selector, rewind selector, rewind selector, rewind selector. Rewind selector. Rewind selector. Rewind selector. Rewind selector. Rewind selector.